progress. Recording stopped.
All right. So this is the order again.
Changed a little bit at the end there, Judge. Pretty much, but.
Okay. What is your name there at the jail? Okay. Thank you. All right, this is case number 19 CR 139, State of Ohio versus Natasha Nelson. Nelson appearing by video or by Zoom from the jail. Her attorney is Sarah Barber, appearing by Zoom, and representing the state is the civil prosecutor King. The defendant was placed on community control back on originally on December 20th of 19, and there were modifications, and that was for here, forgery and the felony. There was a notification filed on March the 1st, alleging the defendant violated Rule 2715-19. The court notified her and set the matter for evidentiary hearing today, and appointed Ms. Barker to represent her. And Ms. Barker, you and client both agree with this matter being conducted by Zoom rather than an in-person hearing? All right. You're all right with that, Ms. Nelson? All right. Now, have you had a chance to review these allegations with the client, Ms. Barker? All right. And does she wish to have a hearing on this, or will it be an admission? All right. Ms. Nelson, just to refresh the record, the allegation was filed March 1st, alleged that you had failed to report on February 22nd of this year as directed, which would be a violation of Rule 2. Alleges that on or before March 1st of 2022, you tested positive for fentanyl, cocaine, and THC while you were in jail, which would be a violation of Rule 7. It alleges you still owe $462.50 in court costs, which is in collection due to your failure to pay, due to violation of Rule 15, and then that you have made no payments on restitution, which was ordered in the amount of $800, which would be a violation of Rule 19. Now, you have a right to have a hearing in this matter, Ms. Nelson, in which the state is required to prove testimony and evidence with these violations. You have a right to have your attorney cross-examine the state's witnesses right after your side of the case. You have a right to present testimony of your own defense. You're not required to do any of those things. In the event that you're found to have violated these conditions, the court will do one of three things. I can continue your community control in the same conditions previously ordered. I could continue with additional conditions that I think are appropriate. Or third, and most serious, is that I could revoke your community control, send you to prison for 12 months, and find you done. Now, do you understand that?
Yes, sir.
All right. And do you understand the right to hearing?
Yes, sir.
And has anyone promised you anything or threatened you in any way to get you to make an admission to the allegations?
No, sir.
Right? And do you admit to those allegations that I just read?
Yes, sir.
Alright? Anything from the state or probation department, regarding this position?
Yes, Your Honor. It's the state's position that this defendant is not amenable to community control. Since being placed on community control in December of 19, this will be her second violation. The previous violation was back in March of 20. At that time, she was continued on community control. She was practically starved. She was told to not give her last chance. But here we are, 2 years later, she continues to use illegal drugs. Despite being on community control for over 2 years now, she has not made a single restitution payment. So based on that, Your Honor, the state would ask that you control your vote to incarceration. Thank you.
Alright, Ms. Barber, anything?
Your Honor, I had the opportunity to talk with Ms. Nelson. She admittedly said that she had forgotten about her restitution payments, and after getting served with her rotation paper, she had stated that she would be able to pay them with her accident if they didn't get it paid off. We seemed very apologetic. However, she was doing pretty well with her sobriety, understanding she did relapse. She has acknowledged that she wants to get into a different relapse prevention program to help her get clean again and stay clean. Had a job at Eric's the last year. Been living in the same residence, and she has been trying her best, and she would like the opportunity to keep continuing on path that she's been going on, hopefully get better.
Alright, Ms. Nelson, anything you'd like to say?
Just that I just had like because I haven't like since I've been here, I lost my car got repossessed because no one knew how to pay for it, and I do have my own place. Like my mom just got testing my kids. I need to help them. Like they're really trying to do the right thing.
So what about your job?
Well, of course I'm here now, but I was getting unemployment I was setting up to get unemployment.
You were laid off?
Well, since I've been here, I'm sure I'm fired. You know what I mean? But I've always had a job. I've always worked. I know I can pay my taxes. I can pay the rent, and the other. So if I can get nothing, but.
When was the last time the defendant was previously tested, for the positive test that we had that she was arrested?
Your mic is muted.
It was on October 12th of 2021. She was negative.
Okay. Had any other drug tests between that time and the first?
No.
Okay, Ms. Nelson, did you have to get tested at work or through any other?
Not yet. I just recently within the last month, like I had bought.
Well, my question is, when were you tested between October of last year and March of this year?
Yes, at work. In my job, I think.
And when was that?
I was thinking there is I completely started I completed that program. I was there and I had a full-time job the whole time that I was there.
And when was it you were at the Phoenix Center?
Last year. After I got out of school.
So when did you get out of Phoenix Center?
I think I got my place in May or June of last year. And I felt that.
Okay, my question was, have you been tested between October of 2021 and March 1st of 2022?
No.
Okay. All right, well, I will give you one more chance. This is definitely going to be the last time. I'm going to continue you on community control with these conditions. Number one, you were extended by term for 1 year, an additional 1 year, and then plus whatever time it was told when you were not reporting the warrants out for you. So that probably would be like a year, 3 or 4 months, or something like that. 2, will be evaluated for SUD treatment, and you'll follow any treatment recommendations. 3, you're ordered to apply your tax refund to payment of restitution first, and then to the court cost. And 4, you're going to remain in jail until you're evaluated, and then if there's a recommendation for residential treatment, then you'll be held until you go to residential treatment. If it's outpatient treatment, then you'll be released once the court's notified that court will not report orders. That will allow you to be released on the condition that you complete the outpatient treatment. But it's going to be your last chance. So hopefully you'll be able to get back to the workforce. But primarily, you need to take care of your issue first. Work isn't the answer, unfortunately, to substance use sobriety. It can be a component, but it has to be secondary to sobriety. So you need to focus on that. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you.
Thank you.
Would you like next?
Tanya Cruy. Did you send it on for this?
I did not, Judge.
In the future, max amount of copies so they know what we have, so they get people lined up. I think she's not sent to 2 since Ms. Barber's here. We're going to get that done. Well, if you don't have her, do you have Emily Lytle?
Yes, I did.
Okay, let's get her then. That will do Ms. Cruy, and then after that, Hausman and Shepard. All right, are you Emily Lytle? All right, this is case number 19 CR 2019, State of Ohio versus Emily Lytle. This is a first pretrial by Zoom. Ms. Lytle's appearing from the jail. Her attorney is Dennis Kirk. He's appearing by Zoom from his office. Appearing from his office is advance of drugs on the grounds of the government facility, aggravated possession of methamphetamine. Final pretrial is April 13, jury trial is April 28. Now, I don't see any discovery request here. Do you request discovery, Mr. Kirk?
I did, Your Honor, I received it.
Okay. All right. Do you anticipate any pretrial motions?
Not at this time.
Okay. Your discovery will be due by the final pretrial then, as well as any pretrial motions. Has been a written sale provided?
There has, and I have not yet advised my client.
Okay. All right. Are there any other motions need to be discussed at this time, or any other matter that should stay at this time? All right. Thank you.
Is there anything I can do on her grandfather,
Who's going?
Emily Lytle?
Talk to our attorney. That's talk to our attorney. I can't really for you. You have to go to the counsel.
Thank you.
All right, are you Tanya Cruy? All right, this is case number 19 CR 212, State of Ohio versus Tanya Cruy. This hearing is being conducted by Defendant's attorney, Sarah Barger. hearing resumed, and also, Mr. King as a prosecuting, assistant prosecutor is hearing. This, Craig was placed on a ILC, for aggravated possession of methamphetamine, a, fifth degree felony, and that was on June 10th of 2020. There was a notification filed and motion terminated back on May 20th. Okay, wait a minute, that's one date. June 10th, on May the 20th is when it was originally filed, so terminated from that. And the hearing is set for June the 20th, June 10th. Okay. And then she failed to appear for that, so a case was issued. And then she was picked up and brought before the court on the 8th of March and notified of the allegations. The court appointed Ms. Barber to represent her. Are you and your client okay with having this hearing being conducted by Zoom rather than in person?
Yes, Your Honor.
You are with that, Ms. Roy? All right. Now, the allegations are that the defendant violated Rule 3 and that she entered the Recovery Council Waverly Transitional January 30th of 2020, left against staff advice on April 2, 2020, enrolled into the Recovery Council outpatient May 6th of 2020, was notified by TRC that she had not been compliant with treatment, and a letter was sent to her closing her file due to non-attendance. Rule 4, she failed to show at the Huntington County Probation Department since leaving treatment. Several attempts made to contact the defendant without success. Defendant failed to provide the office with any changes or has she attempted to contact the office since April 7, 2020. Rule 15 is basically that she did the same thing as alleged in Rule 3 and failed to follow with the rules and regulations of treatment. Now, yes, ma'am, you don't allow shorts in here. There's a big sign out there. Courts are no place to wear shorts or sandals. All right, now, Ms. Barber, get an opportunity to review these allegations with your client. All right, and she wishes to have a hearing, or will she be admitted?
She will be.
All right, now this, Troy, originally when you were put into you pled guilty, when you were put into the intervention program, your case was stayed. It was not a finding and made of guilt. If you are found to have violated these conditions, whether you admit to it or whether it's proven through a hearing, then the court will find you guilty, terminate you from ILC, and set the matter for sentencing. And a sentence of between 6 months and a fine of $2,500 and a possible license suspension of 6 months to 5 years. You understand that?
Yes.
Okay. All right. Does anyone promise you anything or recommend any way to get you to admit to these violations? All right. You admit, you understand the consequences if you admit?
Yes.
Okay. All right. And you are admitting to the allegation?
Yes.
All right. Court then will terminate the defendant from ILC. Finds her guilty. Is there a request for an update? See, she had a bed available either at the Star or at TCC on the 18th and the Star on the 23rd. Is there any reason that either party feels we need to update the PSI?
Yes,
Sorry, Your Honor, no.
Yeah, okay. All right. Then I'll go ahead and proceed to sentencing. Anything from the state?
This is the defendant's first felony conviction. The state would just ask that she be placed on community control in order to complete substance abuse treatment.
Ms. Barber?
I haven't talked to Ms. Curley. She understands that she definitely did not do the things that she was supposed to do in the beginning. I will say that, to her credit, she turned herself in. She in fact called the probation department, spoke with Ms. Sturgill. I believe she spoke with Ms. Sturgill, and she also has spoken with me prior to turning herself in. Turned herself in the day that she told me she was going to do it. She said she was going to come in on Monday, and she did. She was admitted to the counseling center, and she would like to go back. They had said they would take her back. They would take her back as soon as tomorrow if the court would be so inclined to let her go. She has an admitted problem, and she unfortunately was still stuck in her addiction a year ago, and she's working her way.
All right. Ms. Crew, anything you'd like to say?
Yeah.
Now, if I send you back there, it's not a lockdown facility, you walk away once, but if I send you there and you leave again, I can tell you that I'm probably, next time I see you, if that's what happened, you'll probably end up going to prison. You understand that? All right. Let's order the court then that the defendant be and is hereby sentenced to a term of incarceration, to a term of 3 years of community control under the following conditions. First, she is to obey all laws of all jurisdictions and conduct herself in a law-abiding manner at all times. Must report when and as directed. Be truthful in all statements that you make to the probation department regarding your supervision conditions. You must keep your supervising officer informed of your residence and place of employment at all times. May not change either without prior approval. You may not change, or you may not leave the state of Ohio at any time without prior written approval. You must have that pass with you whenever you're traveling out of state. Once you're released from jail, you're not to associate with anyone, with an inmate, any of those, in any correctional facility of any type, that require you to attempt to communicate with anyone in any of those institutions without prior permission. Now, because you're now convicted, you're prohibited under both federal and state law from purchasing, possessing, owning, or using, or having under your control any firearm, ammunition, dangerous orders, or weapon of any other type. If you should do so in the future, that would be a violation and subject you to being prosecuted for felony under both federal and state law. Now, it's also conditioned you should not have any of those items while you're under control, and you're not permitted to have any other weapons of any other type. You're not permitted to purchase, possess, use, and have under your control any kind of a controlled substance, drug abuse, CBD, oil, crack, or analog of any controlled substance that has an effect similar to controlled substances of drug abuse, or any other instrument, device, or thing may be used to administer them for credit administration unless they involve a prescription copy of which you must provide to supervising officer within 24 hours of receipt. You're to submit to drug testing when and as directed. You not purchase, possess, use, or have under your control any type of alcohol beverage or any present place of the soul of being consumed if it's otherwise lawful. You're not to associate with any persons of co-defendant in this case or any other persons in criminal record, member of the gang or other criminal group. Any other person has the past or could in the future criminal offense that violates these conditions unless approved in writing by your supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation in an alcohol marriage type relationship with another without written permission. Must report any contact law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. Must provide your supervising officer financial information records so your ability to pay any fines, fees, or costs will be reviewed. You're referred by your supervising officer or any other probation department officer for an evaluation assessment for any type of treatment, therapy, counseling, training, or education program. You'll be on that order by the court. You submit to that with the recommendation for programming. You'll enroll and complete that. You're required to pay the court costs of this action, make payment arrangements to do that. You'll be required to do 4 hours of community service once you've completed your treatment. residential treatment, at the rate of 20 hours a week, 20 consecutive weeks, unless you're employed at least 20 hours a week, full-time student, or is documented by a physician or prior disability finding you're unable to perform that service. You'll remain in jail until March 18, and you'll be conveyed to the Recovery Council facility. You are to successfully complete the Counseling Center residential treatment program for substance abuse disorder and any aftercare that they recommend. Now, by being placed on community control rather than being sentenced to prison, you're deemed consented to a search without a warrant of your residence, your person, your vehicles, owned by you, or used by you, or any proper place where you are found or that's under your control at any time, any officer of the probation department. Be no fine or license suspension. Court costs are also at a subsequent order. If you fail to make those payments and comply with your probation order, the clerk will collect that through various means, including letters on account, wages, earnings, or other assets you may have. If that doesn't collect it, then the court order you do additional community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your credit by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file a notification of that in writing. You'll be given a copy. You'll have a hearing. You'll be entitled to have an attorney in that hearing. Yet the result of that hearing is that you have failed to comply. At that time, the court would revoke your control and sentence you to prison for between 6 to 12 months and fine you $2,500. If that happens, once you complete the sentence imposed by the court, the law provides that the adult parole authority may decide to put you under post-release control supervision for a period of up to 2 years. It's optional, but it's up to them. The court has no involvement. If they do and you fail to comply with those conditions, they have the right to return you to prison. They can serve an additional period of up to half of your prison term for one or more violations. But if you've been a new felony, if an additional whatever sentence the judge is a new felony could impose upon you, that judge could also authorize and sentence you for committing that offense while under BRC in this case, to an additional period of 1 year, whatever time left on that period of post-release control, whichever greater that occurs, that must be served. Secondly, the sentence in the new case. All right, is there anything further with counsel? All right, thank you. All right, Ronald Hausman. All right. Are you Ronald D. Hausman II?
Recording
All
in
right.
progress.
This is case number 21CR110, State of Ohio versus Ronald D. Hausman II. Mr. Hausman is charged with felonious assault, abduction, domestic violence. This is a final pretrial. No, sorry, first pretrial. Final pretrial is set for April 11, and the trial date looks like it's April 25. Now, I know we've had the evaluation. Is discovery now complete in this case? I think it was before we had the evaluation. They have the discovery where our trucks are muted, by the way.
I think I made the same discovery. I was back in July of last year. I think they applied. I don't see a file stamp.
All right.
I don't see prices and I'll file that tomorrow.
All right. You anticipate any other pre-trial motions?
No, sir.
All right. Is there a written plea offer yet?
There is, and Ronnie and I discussed that as well as today, and we're still fine-tuning it to figure out which one to solve the matter.
Okay. All right. Anything else we need to discuss then on this case?
I just want to clear something up here, Art. Today, according to the assignment notice, today's actually the final pre-trial. Jury trial is April 11th.
Okay.
I think that's correct, John.
Oh, actually, that is right. I see now I scratched out the 25th because we'd already had a first pretrial. So, yeah, this is final pretrial. Trial set for the 11th, so until end of next week.
Thank you.
All right, thank you. All right, Roger Shepard. This is case number 20 CR 248. State of Ohio versus Roger D. Shepard. You're Roger D. Shepard, correct from jail. All right. Mr. Shepard's attorney is William Armstrong. I believe you were just kind of lost Mr. Armstrong.
Yes.
Yeah. Okay. Yeah. All right. And appearing, this hearing being conducted by Zoom, Mr. Armstrong's current in his office, and then the office representing the state. And Mr. Armstrong, are you and your client both were able to this hearing be conducted by Zoom rather than in-person appearance? You're all right, then, Mr. Shepard? All right. Since you're not in court next to your attorney, if you need to talk to him at any time, just let me know. I can put you into a breakout room. The two of you can talk. There won't be anybody else to be present in the hearing. Okay. All right. The defendant has entered a plea of guilty to breaking and entering a fifth-degree felony and theft a first-degree misdemeanor. Court first matter for a pre-sentence report, and I have received that. I'll confess that I actually don't have time to. I just got back at 12:30, so I actually haven't had time to review it, but I'll look at it quickly here. But have each of the parties had an opportunity to review this report?
Yes, Your Honor.
Actually, I take it back. I did review this, I think Wednesday, because I see now some notes in the PSI. All right. All right, Mr. King, anything on behalf of the state?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. Looking at his criminal history, he had prior convictions for breaking and entering, felony 2 burglary, grand theft, and it looks like 4 felony theft convictions. Also, pointing out that the defendant was originally granted a bail bond in this case. He appeared in pre-trial back in January of 2021, and there was a habeas out for a year. He was not arrested until January 22. So given that the defendant could not comply with the most basic requirements of pre-trial supervision, which is shown by the court, I recently believe that he can comply with the community control. So based on that, the state would ask to be sentenced to a term of incarceration. The restitution in this case is $928.97. That is payable to Paula Moody Cole. Thank you.
Paula Moody Cole?
Yes, Paula Moody Cole.
Is that C-O-L-E?
Correct.
All right. All right, Mr. Armstrong?
I spoke with Roger today and consider this here, at least the discovery I had from that office back in 2012. He's basically 12 months here. I like to get it up there and do 12 months. He's asked me to pay it before. He filled out, I believe, was interviewed in drug court. I explained to him he understands the drug court was actually more strenuous than just straight probation. What he told me was that he's asking the health program office. He understands that in residential, he's looking for either residential treatment or starting or people on and then admission into the drug court program. He missed a lot of part of his daughter growing up, now has a granddaughter. He's over 40 years old, more than that this lifestyle. We asked him to take that into consideration.
Mr. Shepard, anything you would like to say?
That's it. Hopefully, what I did.
However, I did forget to mention one thing. This defendant also is currently under custody.
Oh, yeah, that's right here, I forgot that.
I went back to my file again, I searched about it today, I don't, I don't see it in my discovery. I don't know if we might discuss that, and I'll talk about that.
Well, you wanna talk to him about it, because I'm looking here, this is back on December the 2nd of 2020. He had 134 days left. Now, he, see, I'm trying to figure out when he responded. He went to the Youth Reentry Center in January 2021 on an OR bond, and then he left. So, would have had, been a warrant on him then since, January 19th. So on December 2nd, of now 2021, December 2nd, he would have had, 134 days left. And that would have put him somewhere in March, but since there was a case on him, I'm sure that was told. Now, if you want to have a continuance to be able to check with APA, Mr. Armstrong, and talk to your client about whether he wants to reconsider his plea, I'll allow you to do that unless the record reflects that I discussed it. I would think I would have discussed it in the plea, but I don't recall whether I did or not. So we can go ahead and recess or continue this hearing in progress, and I'll have to go back and see if that was brought up. And then also give you the opportunity to contact APA to decide and find out if they did stay his PRC time. Normally they do. If they didn't stay it back in January of last year, then there is no PRC. But if they did stay it, then he's looking at a year on top of any other sentence to get out of this case.
I just checked on the OPRC website, and it indicates that the defendant is still under education.
Okay. So, Mr. Robert, what do you want to do? Okay. All right. given jail time credit of 75 days. Now, I'm going to make history here today. I'm not going to oppose the PRC because it should have run out, and you've been very upfront and honest about that, more so than probably almost any other person I've had here in front of me. And I think that 11 months is a sufficient penalty for what you've done here. Now, if you truly have a substance use problem, and if you truly want to deal with it as opposed to just staying out of prison, then you'll take the time while you're in prison, and more importantly, once you get out of prison, to get yourself some help. But if you were here on a drug offense, something that didn't involve a victim, you had a history of drug abuse, victimless crime, so to speak, that would be different. But I just can't see my way clear to allow somebody who continues to victimize people to avoid the consequences for that. So, not opposing the 1 year PRC is going to be a big thing. So, now don't go back and tell everybody in the jail you escaped that, because I'll start hearing this from everybody. And I guess there's no point in me telling you that because the attorney is going to say it. But this is probably a once in a lifetime thing for me. So, yeah, I know it is for you, and it probably is for me. So, just try to not get everybody's hopes out of it. All right. Now, upon completion, you get 75 days of jail time credit on this sentence. And then upon completion of this sentence, PRC is optional, Mr. Shepherd. And that means that the ADA could then put you under post-release control for a period of up to 2 years. And if you violate those conditions, they can return you to prison, make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence to be imposed in that new case, that judge can also sentence you to an additional period of 1 year, or whatever time left on that PRC time, whichever is greater, for committing that offense while in the PRC in this case. And if that occurs, that has to be served secondly as sentence in the new case. The order to pay $928.97 in restitution to Paul Newton Cole through the victim witness escrow restitution account, and to pay any service fees for that. And that is a substantive order, so even though you may serve your entire prison term, it won't go away until you pay it or you die, whichever occurs first, because it can't be discharged for bankruptcy. Now, you're also ordered to pay the court costs. If you don't make payments on the court costs, then the court could order you to service once you complete your prison term, not while you're in prison, but once you complete it. And that would be an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid. All right. Is there anything further from counsel? All right. Thank you.
I guess I'd like to say thank you, I understand what you're thinking.
All right.
God bless you. We'd like that.
Let's see. We have, I've lost my sheet here. I'm trying to find it. Okay. What did I do with that? Is that Mr. Green out there?
Alan Green.
Alan Green. Okay. Oh, here it is. All right, this is you're Alan Green. All right, this is case number 22 CR 68, State of Ohio versus Alan Green. Mr. Green is appearing by Zoom from the Justice Wagner. He's appearing by Zoom. Appearing on behalf of the State's Assistant Prosecutor King. The defendant is charged with 3 counts of aggravated traffic methamphetamine, 2 in the vicinity of the school, and then 3 counts of aggravated possession of methamphetamine. I believe this is a first pre-trial, and the defendant is set for final pre-trial on April 13, and trial date on April 28. All right. I see that the discovery has been provided by the state. Have you provided your discovery yet, Mr. Wagner?
I am not, sir.
All right, we'll be due by the pre-trial. Anticipate any pre-trial motions?
I do not, Your Honor, if I could ask for, I'll address that.
Okay. And has it been originally provided?
Yes, discovery's been gone over along with the, all of my client already.
All right. Are there any other matters that need to be discussed at this time?
Your Honor, if I could address it, I did go out to speak to Alan, actually, ran into his mother while I was out there, I spoke to her. But he said on a $25,000 bond, I say he understands that these are having to do mandatory times, court, the prosecution, they get, squirrely, they get a guy who will run of that nature. But Alan, I believe, is a lifetime resident, based upon this, I've seen her since like, always been working, around this area. His record has no prior felonies, looks like a handful of misdemeanors. I don't know if the court would entertain even, I'll be realistic and not say even a law modify this, Your Honor. $25,000 is like $2 million. If the court could set something reasonable, Your Honor, maybe his family, his mom, he does have an appointment at Steel Tide, might grant this. So I don't know if the court would consider just reducing it in half, or setting some parameters. They can easily fine, Your Honor.
Okay.
There would be a motion in introduction, Your Honor. I understand this defendant has no criminal history. However, Mr. Wagner pointed out, he is facing 2 out of 2, very mandatory prison time, and is alleged to have traffic that sentenced based on that.
Well, after looking at this record, it is minimal. So I'm going to reduce the bond to $5,000 plus OR, and $171 service fee prior to prior release. And in the same terms of the arraignment entry, which includes pretrial supervision, so if you are able to make that bond, Mr. Green, then you'll be required to report probation immediately upon release. Hopefully you'll make one, and the court will have an opportunity to observe how you conduct yourself while this case is pending, and then convicted, and that certainly wouldn't hurt you at all, help you, and if you don't show up, and violate your bond, then of course it would hurt you. So we need to keep that in consideration. All right, anything further? All right. All right.
Thank you, Your Honor.
Okay, I think that's everybody in jail, isn't it?
Yes, sir.
Okay. Pardon me? Oh, okay. Yeah. All right. I don't think I got that file, man. I think it's laying there on the counter by itself, on top of the ones for judicial release. And Mr. Erskine is supposed to be by Zoom. I think it was going to be in person, but his attorney is in a hearing in Cincinnati. That is set at 2:30, so we'll leave this open. And there's at least a couple of the defendants that are here for the in-person hearing, so counsel can come over here as soon as we get done. Ms. Barker is Mr. Woolridge's attorney. Thought I saw her son. Yeah, there she is. Breakout room was covering it up. Yeah, the bail's going to have to put this in the theater. It wasn't on the docket.
Okay, Judge.
Okay.
Yes, sir.
All right. State of Ohio versus Jeremy Woolridge, 19 CR 169. You're Jeremy Woolridge, attorney there at the jail. All right. This hearing is being conducted by Zoom. Ms. Barker, Sarah Barker, is his attorney by Zoom. and then hearing from the prosecutor's office, Assistant Prosecutor King. Defendant was originally granted international conviction of aggravated possession of methamphetamine in 53 felonies. He was notified of alleged violations after a motion to terminate his file on January the 6th. He came before the court on January the 20th and admitted to violations. And the court then set the disposition for March and ordered an updated PSI, and then had to be continued to a conflict to another date. And actually, I think the first one was continued because the defendant had not reported to the police department. That's what happened. Then he ordered to report on the 4th, and he didn't report then, so a case was issued. And now the matter is set for hearing. I know I did receive the updated PSI and looked at it prior to the last hearing. The court was requested to go ahead and consider this today. It was going to be tomorrow, but Ms. Margaret was not able to move today, and so the court was able to do that. All right. Anything from the state regarding sentencing?
Thank you, Your Honor. This is the defendant's first felony conviction. The state has asked to be placed on speed control. Given his struggle with following all of the admission of this program, the state has asked to be presidential support. Thank you.
Carter?
Last week about the possibility of inpatient treatment. He's completely for it and he's ready to go. Mr. informed me today that he has a bed at Madison House for Mr. Woolridge on Monday. So he would be regularly able to go to Madison House Monday to get his treatment and hoping sometime to do.
All right. Mr. Woolridge, anything you'd like to say? All right. Well, Mr. Woolridge, I'm going to give you that chance. But the first thing I hope you're going to learn in treatment is you need to change your attitude. And that is, you need help. You need to help yourself, what you need to do. No one can take care of your addiction or your problem but you. Other people can provide you opportunities and tools to do that, which is what we're going to do here. But it's up to you to do it. And, you couldn't even get yourself to a report. So I had to have you arrested. And, of course, again, it's the age-old law, I don't have a right. But everybody seems to have a right to be able to go buy dope or to get high or to commit crimes in our county. But then when it comes time to come forward, oh, man, I got a problem to get crap. And so, that's the attitude that needs to be changed. That is this. If I'm going to stay out of prison, I'm going to do it. There's not going to be any excuses. That's the attitude you have to have. If you don't have that attitude, you'll be back here in under 6 months and probably go to prison. But I'm going to give you the opportunity. I'm going to put you on 3 years of community control, the supervision of the probation department. You're to obey all laws of all jurisdictions, conduct yourself in all body manner on time, you report when and as directed, you prove on all statements you make to the probation department regarding your conditions. You're to keep them informed of your residence, place, and employment at all times. The correctional facility once you're released from custody, nor may you communicate or attempt to communicate with anyone who is in any of those facilities without prior permission. And because you now have a felony conviction, you're prohibited under both federal and state law purchasing, possessing, owning, using, or having under your control any type of firearm, ammunition, dangerous or weapon of any other type. And if you possess any of those, you're subject to prosecution under both federal and state law. You are not permitted to purchase, possess, use, have under your control any controlled substance, drug abuse, CPOL, kratom, or any variant or analog of a controlled substance that has effects similar to controlled substance drug abuse, or any other instrument, device, or thing that may be used to administer those, rather than administration unless you have a valid prescription. and you must provide a copy of that and 24 hours received to your supervised officer. You submit drug testing when and as directed. You may not purchase, possess, use, or have under your control any kind of an alcoholic beverage, nor may be present in places where the sold or being consumed deemed otherwise lawful. Do not associate with anyone who is a co-defendant in this case, or any other person that has a criminal record, member of gang, or any other criminal break, or any other person that has a past criminal offense providing these conditions, unless that's approved in writing by a supervised officer. That apply to any family members other than those who were residing with you residing with immediately before this morning. You must report any contact with law enforcement or any other conviction or citation of the charge of violating the law not later than the next business day after that occurs. After the date of this order, you're not permitted to marry or establish cohabitation of common law marriage type relationship with another type of commission. Thus provide your supervised officer with financial information records so your ability to pay any fees and costs will be reviewed. You're referred by probation department for any evaluation assessment or further treatment beyond that order by the court or any other programming. Submit that. There's a recommendation that you undergo that program. You will be required to enroll in success to complete that. You're required to pay court costs, make payment rates to do that. You're required to do 400 hours of community service, or 20 hours a week, 20 consecutive weeks, unless you become employed at least 20 hours a week, a full-time student, or you have documentation from a physician required disability finding for physical unable to do that. We'll remain in jail until Monday, is that March the 21st? And then we'll be on that date required to go to Massey House and successfully complete the treatment, residential treatment, and aftercare through the Massey House program. Now, it's not a lockdown facility, but if you leave there against their advice, then that's a violation of your community control. So we need to understand that you're expected to complete that. Now, by being placed on community control rather than be sentenced to prison, you're need to send to a search without a warrant of your person, your residence, vehicles owned by you, or any of the property place where you're found or under your control in any manner by any officer of the probation department. No fine or driving suspension imposed. If you fail to pay the court costs, the court could order you to do additional community service, and beyond that already ordered, and give you credit for each hour you work, and higher rate, for each hour you work, to reduce your judgment on that amount until paid in full. In the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that in court. You'll be served a copy with the entitled to hearing, and be represented at that hearing by an attorney, and if the outcome of that hearing is that you have failed to comply, then the court could revoke your community control, and at that time sentence you to prison for a period between 6 to 12 months, fine $2,500. If that happens, unless you complete the sentence ordered by the court, the adult parole authority could, at their option, place you under post-release control supervision for a period of up to 2 years. You don't have to, but they can. It's up to them. If they do, you can supervise on those terms, and if you violate those conditions, they have the right to return you to prison. You know, you serve the entire term set by the court for an additional period of up to half of the prison term for one or more violations, but if a new felony, in addition to whatever sentence the judge in the new case proposed by the judge is also authorized sentence in this case to an additional period of 1 year or whatever. Additional period of 1 year or whatever time that on post-release control, whichever is greater. All right, is there anything further from counsel? All right, so we remain in custody until Monday, Mr. Right. And Ms. Barber, your clients are at least Mr. Local, Mr. Goddard. Are you Mr. Goddard?
Mr. Rick.
Oh, Rick, okay. All right, well, at least Mr. Local is here. He's your client, I believe. Okay, all right, I don't know about Mr. Goddard and Ms. Stokes. So. All right, we'll see you over here in a few minutes. I'm going to leave this open because the Erskine case at 2:30 is going to be by Zoom. Thank you. Okay, so I heard you're at the Now, there is a procedure that's available under Ohio law that's called intervention to a conviction for offenders whose crimes involved were caused in part, at least or in whole, by substance use, addiction, abuse, or mental health issues. And if that is the case, and you're otherwise eligible, which you are, then if you plead guilty, rather than sentencing you to a term of community control or prison, the court separately doesn't find you guilty. And then if your case is stayed means it stops or is on hold. And then I wait for a report from the probation department. Now, this program can be up to 5 years. I always order 2 years. I think that's sufficient time to determine if that person will be successful or not in that program. Now, the advantage is this. Even though you pled guilty, and if somebody looks at the file and wants to see guilty there, I haven't found you guilty. Under law, until I find you guilty and sentence you, there is not a conviction. And so you can still report that you don't have a felony conviction until further with the court. And if you do successfully complete your treatment plan and you comply with some other conditions of supervision, which are much less strict than the normal ones for persons convicted, and your treatment plan also includes you have to abstain or not use any illegal drugs or alcohol for a period of at least a year. That's why I go for 2. If you do all those things and pay your court costs, then the case is dismissed. And then I set it for a hearing to seal the record, and I have yet not to seal one. And in that case, then the record becomes private, removed from public domain, and you can then tell people when you are asked if you have any felony convictions, you can say, no, I do not, because you don't. And that record can't be accessed unless you were to get charged with another felony in the future, in which case the prosecutor or the court, probation department could then access that record, simply to show that you've been in that program once already. And so that's the advantage. Now, the disadvantage is this. You are pleading guilty, and so you don't get to try the program, see how it works, and then not make it say, well, it's worth a shot, let's have a trial. This is your last chance to say, no, I want to have a trial. And so that's the disadvantage too. Okay? You understand that?
Yes, Your Honor.
Okay. So this agreement says you're going to plead guilty to count 1, breaking and entering, under 2911-13A, 5th degree felony, and criminal damaging under count 3, under 2909.06A1, Vice Code, 2nd degree misdemeanor. Further states that you understand the maximum penalty for count 1 would be 12 months in prison, if the prison term imposed minimum 56 months, maybe the amount in between, and a fine of up to $2,500. For count 3, there's a maximum penalty of 90 days in the county jail and a fine of $750. You understand that?
Yes, Your Honor.
Are you facing any felony charges anywhere else?
No.
You're not on control, probation control, or post-release control for felony?
No.
All right. Now, in the event that you fail to complete the program successfully, that would only occur if the probation department filed a written notice of that with the court, served you a copy, and then we would have a hearing and you would have it returned. And then the outcome of that hearing was that you failed to comply. Then at that time, you would be found guilty, then you would be sentenced. And that could again be control for up to 5 years, it could be a fine, it could be prison, or a combination. And if that occurs, then you do have a felony record. If you're sentenced to prison, then in addition to whatever sentence the judge in that new felony, if you're sentenced to prison, once you complete the term set by the court, the parole authority could put you in post-release control supervision up to 2 years. It'd be at their discretion, it's not mandatory that they make a decision, and if they do, you would supervise the terms they set by parole officer. If they find that you failed to comply during that period of time, they can return you to prison, make you serve additional period up to half of the prison term that I imposed for one or more violations. But if you committed a felony, then an additional sentence judge in the new case can impose upon you. That judge will also sentence you, in this case, to an additional period, or for committing that offense while under post-release control, in this case, I should say, to an additional period of 1 year, whatever time left on that, 2 years of post-release control, whichever is greater. That occurs, that must be served consecutively to the sentence in the case. You understand that?
Yes, Your Honor.
Now, even if you're convicted, because you didn't complete the program, I don't have to sentence you to prison, I can still give you community control control, which means you put under supervision probation term for a period of up to 5 years under different terms that are more restricted. And if during that period of time the probation department felt that you were not compliant, then again they would notice that with the court. You'd be entitled to a hearing, be represented by an attorney, and if the outcome of that hearing was that you failed to comply, then at that time the court would revoke your community control and then sentence you to prison and for the 26 to 12 months, fine, 25. You understand that?
Yes, sir.
Right now, count 1 alleges that on or about September 22nd, 2021 in this county, you did by force, dealt with deception, trespassing a building in Sunoco on East Main Street, so non-occupied structure, first commit their in theft offense, defined in ORC section 2913.01 or felony, violation section 2911.13a, so that's the charge of breaking and entering. Count 3 alleges on or about September 22, 2021, County, Ohio, you did phone by any means, knowledge that creates substantial risk of physical harm to a dumpster block, property of sterilized medical marijuana dispensary without their consent, violation section 2909.06A1. So that's the charge, total damaging second degree misdemeanor. Now, Mr. Goddard, do you understand what you've been charged with in those 2 counts? What the state said you did, when, where, how you did it?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible offense, my trial, raise the trial, possible trial by attorney?
Yes, Your Honor.
Are you satisfied with your advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any type of drugs or alcohol at this time?
Can you repeat that?
Are you taking any prescription drugs?
Yes.
And do any of them doing here or what's going on?
No, Your
Uh, has anyone threatened you in any way to get you to plead guilty here today?
Honor. No, Your Honor.
Right now, there is language on page 2 which indicates that you're going to plead guilty to count 1, count 3, statements, count 2. States recommending intervention of conviction, you agree to make restitution for life medical marijuana dispensary amount of $15. Joined in several with CHCL, and you agree to make full restitution of stuff. Yeah, is that your understanding of the agreement?
Yes, Your
Anyone
Honor.
promise you anything other than that in case you plead guilty?
Yes.
Now, is anyone promise you anything other than what I just read?
No.
Do we have a number of restitution for Sunoco?
No, not for Sunoco. They have not provided us with anything.
Okay.
So there is a $15 joint and several for the other place though.
No pun intended.
Right.
Okay. All right. Now, do you hold any license or certificate from the state for any state agency that governs any profession or occupation?
I have a driver's license.
Okay, but other than that, nothing in terms of jobs, state technician or anything like that. All right. Now, because this is your last chance to stand under not guilty pleas or defend against this case, you must understand the constitutional rights I'm going to explain to you here before I can accept the plea. First, you have attorney Ms. Barbara represent you. I wasn't sent to try to work the case out, but provide any defense that might be available to you under the laws you wish to provide. So, if you do not want to do this, want to defend against the charge, you'll still be represented by Ms. Barber, and she'll defend you, including a trial if that's what you want. You understand that?
Yes, Your Honor.
Now, you have the right to have a jury trial in this matter, in which 12 people will be selected from this county that are summoned for jury duty and trial. After they are selected, the evidence will be presented, they instruct them alone, and that jury will have to decide by unanimous verdict whether to say proof or guilt by proof beyond reasonable doubt. Unanimous means all 12 have to agree. Now, if you did want to have a jury trial, if you did want to plead guilty either way, which means give up the right to have a jury trial, in that case, you have to hold a court bench trial with the judge, either one will hear the evidence, apply the law, and decide whether or not to state proof or guilt beyond reasonable doubt. Do you understand that?
Yes, Your Honor.
The Constitution, you have a right to confront the witness against you in open court to cross-examine them through your attorney. What that means, the witness against you has to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose is to bring out evidence to help your side of the case. Do you understand that?
Yes, Your Honor.
And the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, just like the state. So if you don't have any, if you have witnesses you're not certain are going to be able to come in voluntarily, it's your request for court issue of court order that's a subpoena. That forces those witnesses to come to court, be able to testify for 1 to 2, even though they don't want to be here. It's the same way state's witnesses are required to come to court. You understand that?
Yes, Your Honor.
And under the Constitution, you have the privilege against self-incrimination, which means you're not enforcing of evidence as a matter of any time, including a trial. No one can ever make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, except in one situation, and that is there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
The Constitution, you're presumed innocent until proven guilty by the state of Ohio in every essential element of offense charge. That means that if the burden of proof isn't on you to try to prove you're not guilty, simply because you've been accused, the burden on the state to prove that you are. In fact, you're not even required to present any evidence in your defense at trial. You may, but you're not required to. Whether you do or not, the burden of proof remains on the state to prove your guilt by proof beyond a reasonable doubt in every essential element of offenses charged, both of them, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Right now, originally, you entered plea not guilty to these two charges, which denied, actually all three charges, which denied the allegation, denied the committed crime, and exercised all of the rights I just described. If you change your plea to not guilty, that's the opposite not guilty plea. The guilty plea admits the allegations and the first and third counts of the indictment, admits that there are crimes, you committed that crime in each count, and that plea waives gives up all the rights I've described to you today, except the right to counsel, which you always have, no matter what you plead, without exception. Plea guilty waives gives up the right to have a jury court trial, waives gives up the right to confront witnesses, cross-examine for your attorney, waives gives up the right to use a part of the court to compel force witnesses to be in court to testify for you, just like the state. Waives gives up your privilege against self-incrimination because you're saying you're guilty, that's what she finds you guilty. The waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. Objection to being sentenced immediately by the court. Finally, waives gives up the right to appeal if you feel you have had up to this point in the case. If you're sentenced to a maximum, under certain limited circumstances, you could be an appeal filed, but you have to be filed within 30 days of your sentencing and your being filed. You understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
Right? And are you entering into this agreement to plead guilty or intervention voluntarily?
Are you entering the plea?
Yes. Yes, Your Honor.
Okay. Now, do you have any questions about the intervention and legal program, what's required of you?
No, Your Honor.
You understand it?
Yes.
Any questions about the charges?
No, Your Honor.
You understand those?
Yes.
You have any questions about the plea agreement?
No.
You understand it?
Yes, Your Honor.
Any questions about the constitutional rights?
No, Your Honor.
You understand those?
Yes.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here this morning?
No, Your Honor.
You understand that?
Yes, Your Honor.
Is there anything else you'd like to speak to Ms. Barber about before we go any further?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea, plead guilty to the first and third counts pursuant to the terms of this agreement we just gone over? Is that your decision?
Yes, Your Honor.
All right. And as to the first count, which alleges on or about September 22, 2021, Highland County, Ohio, you did by force, stealth, and deception trespass in a building, Sunville, East Main Street, Highland County, non-occupied structure with permit therein. A theft offense is defined in ORC section 2913.01 or felony. Violation of section 2911.13a of the Ohio Code, charge break and entering a fifth-degree felony. Carrying possible prison term between 6 to 12 months, fine $2,500. How do you plead?
Guilty.
As to count 3, which alleges on about September 22, 2021, Highland County, Ohio, you did knowingly by any means cause or create substantial risk of physical harm to dumpster walk, property of Verilife medical marijuana dispensary without their consent, in violation of section 2909.06A1 of the Ohio Code, charge of penalty a third-degree misdemeanor carrying possible prison term of 90 days and $750. How do you plead?
Guilty.
Thank you. You can be seated. Court finds in this day open court defendant was violating all of his constitutional rights, made a no intelligent, voluntary waiver of the same pursuant to Rule 11. As to counts 1 and 3, counts 2 dismissed, defendant pleas are accepted. However, the court finds that the defendant's drug dependence was or mental health was a factor that was led to the commission of these offenses, and that his treatment, rehabilitation, substantially reduced the likelihood of future additional criminal activity. He is accepted in the appropriate certified treatment plan for cytopenic mental health. He's otherwise eligible for police control. He's not a repeated dangerous offender. He's otherwise eligible for intervention with conviction as stipulated. Therefore, the court accepts the guilty plea, but will not make any finding at this time. The matter is stayed. Any report from probation as to the defendant's progress in the program. You'll be placed under control supervision of the probation department under the terms that have been adopted by the court for this program. And they'll give you a copy of those, go over that with you. That'll be for a period of 2 years. You'll also be required to successfully comply with your intervention plan, which includes abstaining from using drugs or alcohol for a minimum of 1 year. You're required to comply with all the other conditions set forth by the probation department. If you successfully complete your intervention plan, remain in compliance and all other conditions, and pay your court costs, then at that time, upon notice of that, the court will dismiss the charge against you, no charges, and will set the matter for hearing to seal the record. In the event that it's alleged failure to comply, the probation department will file a written notice of that with the court, serve a copy on you. You'll be ordered to hearing, you'll be represented by counsel at that hearing. And if you are found to have failed to comply, at that time, the court will terminate you from the intervention legal provision program and order, and you'll be subject to be sentenced at that time to between 6 to 12 months and $3,250. And also restitution of $15 is ordered. And you'll pay that through the victim escrow program. And you have service fee for that. All right. Anything further, counsel?
Yeah.
All right. You're no longer under pre-trial supervision. You report that probation department. Just leave here. Let them know you're now in the intervention program. And Mr. Archie probably do want to supervise you on that. Maybe with another officer will see him. And they'll set that process up for appointment for you to go over all that paperwork. All right. Thank you. All right. Mr. Washington is on the line now.
Is
Are
Mr.
you
King,
for Mr. Erskine, are you handling this?
if either one of us, is Mr. King on there?
Yeah, okay. Oh, Mr. King's there, okay.
Okay.
All right. Okay, Mr. Erskine, okay, you're Ty Erskine, appearing from the probation department there?
Yes, sir.
All right, there's 3 cases here involving Mr. Erskine. 21CR141, 21CR142, 22CR034. This hearing being conducted by Zoom, Mr. Washington. You need to unmute Mr. Washington. He's calling Hamilton County. His client is appearing from the probation department. It's a pre-trial. Mr. King is representing the state. All right. Now, I know the first 2 cases are coming out soon for trial. I know we've had at least 2 pre-trials in each of those. So, where do we stand on that? Council wants to report.
Your Honor, also we have first is I am speak with recent resolution of all 3 cases.
All right. Well, if you can, we need to get these are set for the 18th, so we need to get these in for the first month. They wait before. So if you would call the court at the top of the assignment commissioner, get a date for a hearing, and we'll put these on. I can do it sometime next week, I'm sure. The week after it's problematic because we have 2 defendant engaging in pattern drug activity, drug cases scheduled on Monday. There's 2 defendants, and that probably will go most of the week. So, yeah, go ahead.
I actually, my first pre-trial in Hamilton County, cases going to take that week.
Which week? Next week?
It's going to take, start Monday, yes.
Okay.
And on the, sorry, I lost my calendar.
All right, go ahead.
Is the court saying that we can be 80%?
Well, I'm by the 4th. 4th of April would be Monday following. I could probably do it on 1st. I think our case may be resolved, finished on either Wednesday or Thursday.
I think we're going to have a great comment on the county because the prosecutor is calling motion to continue that case.
Okay.
From the 4th. It has to be ready again. Actually, in front of Judge Bates, saying, Judge, I'm putting the motion to the press right now. So I think we're ready to do this.
Okay.
But what I can do is log in tomorrow.
Okay.
But I think let us know if we can do that
All right, thank you. All right, I believe that's all of the Zoom.
Yes, sir.
All right, Mr. Bolger? It's been so long since I've seen you, I don't remember if you were all white haired then or not.
I was.
It's been 2 years.
Yeah. Good about that.
Yeah. You probably enjoyed that absence, so.
On this.
I didn't mean for me, to her. So.
Right.
All right, this is, case number 22 CR 62, State of Ohio versus Bryson Lee Rickman. Rickman is, present with his attorney, James Bolger. The, state's represented by, Assistant Attorney Collins. The, defendant is charged with aggravated trafficking of fentanyl-related compound, aggravated possession of same, for 53 felonies. I believe this will be the first pretrial. Final pretrial on the 21st, and a trial date on May 9. I see Mr. Bolger just entered his appearance Monday in a request for discovery. Has that been provided yet?
Your Honor, we actually provided that to Ms. Barber, who is the original attorney, and today in court, she handed the paper copy of that and bill of particulars and everything to Mr. Bolger. So I did forget to tell Mr. Bolger, it's in the discovery that we will need to bring a flash drive to the office so we can gather them the buys on it.
Okay.
Send them to.
On drive with a video?
Yes.
Okay. All right. I know you've only been in this a short time, Mr. Bolger, but do you have any inkling as to whether there may be any pretrial motions?
I had a chance to quickly review a narrative and discovery materials. I don't anticipate a motion. However, I haven't seen the video.
Sure. Well, you'll have it until final pretrial file, and your discovery will be there as well. And then, was there a written offer included in Barber's materials?
There was. Did she give that to you?
Okay.
I do that from my client. He understands that there could be, probably will be, a second for felony offense presented at a grand jury within the next month.
Oh, okay.
That's right. I advised Mr. Bolger that
Right.
today.
All right, anything else then?
Thank you.
All right, stay in touch with your attorney and proceed in the next pretrial.
Thank you very much.